Okay, so we're back on the record. It's 3:08. So we've had a chance to discuss amongst ourselves the outstanding issues, and this is where we've come down. The parties may call any of the relevant administrative law judges. We'll do live testimony, though, not simply the deposition transcripts, which can be used for impeachment, obviously, but we'll do live testimony. We will allow an inquiry only as to whether each individual administrative law judge leaked the letter, or whether they have knowledge that another signatory leaked the letter, and then an appropriate follow-up to that. But we're not going on an expedition into who outside that group would have leaked the letter. It's only relevant, we think, however minimally, to the good faith basis argument. As to membership in a union, we'll have some language in order that will follow, but we'll allow limited questions on their personal involvement in efforts to join to either unionize. There's still a lot of lack of clarity about when that process began, and to the extent that it might weigh in on the administrative law judge's particular bias in becoming signatory to the letter. We'll allow limited. We're not, again, this is not we're not looking to go down, this is not a unionization hearing. It's not whether they have right to unionize. It only has to do with their own personal efforts or actions insofar as it affected their state of mind and motivation to sign a letter. Finally, as to the attorney-client privilege issue, we are not comfortable making a blanket ruling requested by Office of Government Ethics that no attorney-client privilege exists, or certainly not one that can be asserted at this stage. We might feel differently if it was at the investigation stage, but we're not comfortable doing it now. There's significant differences between this case and Nichols versus Fenty to give us pause before making such a sweeping decision that would have significant ramifications. So what we propose is to deal with it on a subject-by-subject basis during the hearing as it comes up, and we will be very clear that the proponent of the privilege, as is recognized in the case law, has the burden of establishing the privilege exists. And I would emphasize to whoever is going to assert a privilege that the nature of the relationship is very important here, and so we are mindful of the fact that there are a bunch of different potential attorney-client relationships that exist. General counsel to agency head, agency to Leftwich and Ludaway, executive office of the mayor, Leftwich and Ludaway, and possibly, and we don't know this because we don't know the evidence, personally and individually between Ms. Oden, Tyson, and Judge Walker, since they were in business together. And to the extent that that poses other complications, if that is going to be the nature of their claim, we'll have to address it. I would suggest to the Office of Government Ethics, if you're anticipating that Ms. Oden, Tyson, or Ms. Walker or Judge Walker are going to assert the privilege, that a waiver by the relevant entity that holds the privilege would solve the problem. Although I will scroll it back even one further step and ask, given the fact that you obviously don't know what they're going to say, since they haven't said it, do you really need it in going forward? But we'll have to take it up group by group and topic by topic. And I realize that frustrates the process in some degree, but because we are not confident that a public exposition of this will not cause greater harm once the confidential information is out there, since we don't know what anybody's going to say, we're going to have to proceed this way. And so that's where we stand. Well, we'll issue an order memorializing all of this stuff, so you have the language. Yes, ma'am.
Quick question. So given now that we have the ruling on the deposition transcripts,
right,
I may want to amend my witness list by adding a couple people?
Absolutely. Absolutely. The same thing with respondents, now that we've got that clarity. But if you need to adjust for the ALJs,
right,
of course, that's what we're talking about here.
So you just want us to just redo it and send it out?
You can. You could do a one paragraph. Don't do the whole thing, but just so that we have a list of who you expect to call.
Right. That's what I'm getting at.
That's fine. There is one other, we will grant all of the requests for hearing subpoenas that have been submitted except for the one for Charles Willoughby. And if you could all talk about the Brian Moore issue and see whether or not we need a subpoena for him. Now that we're going to let just the limited questions on the leak, whether you think that you can't, something you can't stipulate to, if it's just an email when it was received. If you can't, then let us know. But we're allowing that, just that very limited area of inquiry. Okay. Anything else on those issues?
Yeah, I have one question for clarification.
Yeah.
As I was reciting in my argument, the letter was leaked. That was one issue. But for 3 or 4 months prior to the letter being leaked, it's our contention that the ALJs, some of them were speaking with members of the media, providing them with information about internal operations at OAH, and then in turn the media was submitting FOIA requests about those internal operations.
You certainly can. I think you can ask about contact with the media in the run-up to the letter being released, not just the letter. Right. Yeah.
And we were asked in the order to bring the subpoena request for signature
That's
today.
fine. All right. And we'll talk. Hold on to this for 1 second. Let's talk about logistics, because that might affect how we deal with this. Obviously, we don't need all the witnesses sitting here every day. So we'll do a 30-minute on-call. You're all very experienced lawyers. You can manage estimating when you're going to need them. Just do your best so that we're not sitting around waiting for long periods of time, waiting for your witnesses. We can be flexible, call people out of order, whatever you need to do. We are going to record the proceedings as we are now, as well as having a court reporter. We're not live streaming as a practical matter. We don't have the capability anyway at the moment. At some point this room will, but not now. So it will be a backup recording essentially to the reporter.
And meaning that it's not going to be posted online either, right?
No, it will not.
People can't, other witnesses can't.
That's right. It's not going to be posted online. I mean, at some point
sure.
when the case is all concluded, it may be that the audio portion is posted the same way we can post our other public meetings. But while the case is going on, while it's being deliberated, while it's being decided, it won't be posted online.
And I'd make the same request for today's proceedings and any other preliminary proceedings too,
Absolutely.
Especially where we spoke about witness proffers.
Absolutely.
And so we're clear there'll be a rule on witnesses at the outset.
You've
sorry,
anticipated my next point. So the rule on witnesses will apply. So any witness who will be testifying in the proceeding, except for the respondents themselves, need to be outside of the hearing room while other witnesses are giving testimony, and they should not be told or share. Other witnesses' testimony should not be shared with them by the lawyers or by the other witnesses. The subpoenas, it's your preference. I mean, you can, if you want to make them all for Monday and then just talk to your witnesses directly. If you have a hostile witness, but a witness who you're not exactly chatty with, and you need to change the date and make it closer in time to when you're actually going to call them, I'm happy to redo it, if you will. Whatever works best. You know your own witnesses better than I do. The administrative law judges are in the building, so I would ask you just to be considerate of their hearing schedules, and to the greatest extent possible, we'll give you leeway, Ms. Battle, Mr. Conti, if you wanted to examine a administrative law judge as being direct examined by Office of Government Ethics. In other courts and other worlds, you might have to recall them and do your own direct. That won't happen here. You'll be able to do what you need to do while the witness is present. Obviously, we expect the respondents to be present during the hearing itself. Obviously, preliminary matters, they don't need to be here, but during the hearings, we expect them to be here. What I would suggest to all parties is to remind yourselves of the rules, our governing rules for hearings, just to make sure that you're familiar with kind of how we proceed. It'll be fairly informal in the way we handle things. You're going to provide us, and you already have, but OG with binders of exhibits that we will follow along. We will not necessarily read the whole binder before we start the hearing. We will read things as they become relevant and admitted along the way. If there's something you need us to see in advance, you think we should read in advance, by all means, give us a heads up. Witnesses come, you might want to take a look at this before the witness testifies. We're happy to hear that.
I'm sorry, I'm just a little bit confused.
Yeah.
So if it's before the hearing and it's not in evidence, why would the trier of fact be reading it?
So you're going to hand us binders of your proposed
Well,
exhibits.
that's because you ordered us to, but
Yes.
why should you have things that are not in evidence before they're in evidence? I mean, it's one thing to say, okay, we gave it to you just for convenience, but
That's
why
right.
would you be reading it before it's in evidence?
Well, we're not going to. I mean, I guess what I'm saying is don't expect us to read anything in particular. Like, I mean, there are things in there that most certainly, you're having bank records that undoubtedly you're going to move into evidence. I'm not looking at the bank records before they're in evidence. I'm just telling you that that's,
I understand.
but we're not a jury. We're lawyers. We're a board and we could see things, but we're not, we're only going to consider, and things will be part of our deliberations and findings, only things that are actually admitted into evidence.
Right. That's what I'm getting at.
I understood your statement that if we needed to look at something in advance.
Right.
That would be something that was perhaps of a relatively complex nature,
Yeah.
or taboo nature, whereas you would want us to be familiar with it so that we
Right.
could participate.
Right. So that we,
My question is based on, so why would you be looking at something that's not yet in evidence?
because you anticipate moving it in and you think that it will move things along if we don't stop in the middle of the hearing to read it. If you think it's important that we know it.
Okay.
It's a process that we actually do fairly often here.
We'll know it, but we won't know it until it's.
We didn't do it in the other hearing.
Well, that's because there are only a handful of documents in the other hearing. But in Superior Court, I mean, in other courts in the District of Columbia, it's not unusual for, especially in a bench trial, which essentially this is, for especially when you're going to provide us with the exhibits in advance, so we're not spending all of our time moving paper back and forth. If there's something that you think that we need to see that will move things along, by all means, let us know. If not, don't feel free not to. I mean, no one's forcing you to do this. It's all a matter of convenience and expediting the proceedings. Finally, just in terms of post-hearing proceedings, we do not anticipate asking the parties to submit proposed findings of fact and conclusions of law. Enough paper has been filed in this case already. We know where your positions are. So we thought we would just tell you this now so you don't spend your time during the proceedings worrying about it. We may, if there a particular legal issue comes up, obviously require a request that the parties brief it, but that would only be on an ad hoc basis. And other than that,
In all of the scheduling orders that I've read, there is a period for summations, which I took to mean some type of a final oral
Yes.
summation or argument.
Right.
Will that be provided for
absolutely,
still?
absolutely. And we
Sorry,
can,
what was the question? Will that be?
Provided for. Will we be permitted to provide?
yeah,
some-
absolutely. There'll be closings. And as you will recall, when we scheduled the hearing, we left a week in August, a few days in August, in case we had some cleanup matters or to do, and we can decide as we go along what works best. Either do the argument then or do the argument at the close of the evidence, depending on what the party's preference is.
Okay.
So we'll stay pretty flexible with that.
Chairman,
Yes, ma'am.
I know that we expect that all board members will be present for all sessions, but in the event one board member is not present, but so quorum and come forward, that I gather there will be no objection by the parties as long as the absent board member familiarizes herself with the events of testimony of that day.
And how will you do that?
By listening to the audio and reading any transcripts which may have been prepared to that point.
Yeah, and our rules provide for that, by the way, explicitly. So, all right. Anything else? All right. Okay, with that, we'll issue an order in the next day or so summarizing what happened today. And thank you all very much for your cooperation and preparation. It is now 3:24, and we'll adjourn until the actual hearing of July 14th. And starting times, 10 a.m.?
That's what I assumed, so I put that on my subpoenas.
Right, 10 a.m.
I guess my question is, if we did talk about this at the pretrial, our preference would be to start earlier if possible, because my understanding is we're adjourning at 3 each day. and that provides for a pretty short day in terms of testimony and getting all these witnesses on. So, or staying later. I mean, it just if we're starting at 10, taking an hour lunch break and
Right.
ending at 3, it's basically a half a day of testimony.
Well, first of all, we had actually asked for an end time of around 3:30,
Right.
3, just a little bit. And that was a loose, I mean, obviously if we're in the middle of something that's got 15 more minutes, it's not a hard and fast, but
I'm willing to cut
to
the
you.
lunch break to half an hour
eh,
and go to 3:30. I know that we set an abbreviated hearing date so that staff could attend to other matters and give an update there,
Sure.
and staff moving forward.
So we'll do that. We'll just plan on a half-hour lunch and then 3:30 end time. Start at 10.
Okay.
Okay. Great. All right, so 3:25, and we are adjourned. Thanks, everyone.
Can I send this back with you? Thank you. Bob, we don't need to sign, right? It's just you, right? Okay.